yourself. Hello, Shariar, I see that you've joined in again. Can you do a quick sound check and please rename yourself?
Hey, can you hear me now? Sorry,
Yes.
I just want...
Yes, that's good. I think we have both of our experts on now.
Wonderful, yeah.
Hi and welcome.
Ms. Acosta Vargas, welcome. Could you please change your name because they're showing you as...
How do I change my name?
When you...
There are... Yeah, please explain.
When you go over to your name, which is host 1000, you can just see that there are two options. One,
where to go there?
Okay. Right. So there's a participants list on the right side of your screen. Can you see that?
Participant.
Right.
Yes.
So
okay.
one of the host 1000 names is you. If you hover over each of them, I think you'll see a more button, and one of the options under that more button should say rename for you.
Let me go there.
Yeah. The one with the video and the mic on is you, so you can just rename yourself from there. Yeah.
Participants, goals, more, rename.
Okay, that's updated. Thanks.
Thank
Miss
you very
Otani. Thanks.
Yes.
Otani, ma'am, can we also ask you to do the same?
Hello.
Hello. Hi. Hi, ma'am.
Yes, the sound is okay. Good enough. I think the right is not okay.
Right. It would be better if you could be slightly louder.
Hello. Yes. Can you hear me?
Yes.
Okay. Good.
Hi, everyone. Thank you for joining. We'll be starting shortly. Please just give me 1 minute to prepare.
I see one person is still not named.
I think that's Miss Otani.
Madhu, can I ask you something?
Yes, please.
Yeah. Are we going to have interpretation?
Yes, we do have. We have Bangla, Nepali, Spanish, and French.
Okay. Then I
Yes.
can speak in Spanish.
Yes, you can. Yes, you can.
Oh,
yes.
This is a great pleasure. Thank you very much. Are you going to give us instructions on the to have a video or not? Because I don't know if we should be with the video all the time or only when we speak.
It's only when we speak, but I think we'll just give those sets of instructions in a few minutes. As we go live, we'll just give the instructions.
Okay. Do you want to tell me something about the before beginning?
Actually, we are already live, it seems, which is why I'm hesitating to say anything. I will be introducing the consortium and giving the background. But by mistake, we already went live before while we were still in the prep session.
It's fine.
Yes,
it's fine.
yes,
It's fine. Don't
yes.
worry at all. Thank you.
Madhu, if you're ready, I can start now with housekeeping.
Yes, please. Yes.
Okay, great. Hello, everyone, and welcome to today's event. My name is Nadia. I'm a communications officer from ERA Asia Pacific. Thank you for joining us today. This panel, titled Prioritize Prevention, Question Criminalization, Reframing Responses to Child Marriage, is brought to you by the South Asian Consortium, FIRE. A few housekeeping rules before we begin. Please turn off your videos and mute your microphones when you are not speaking. If you are experiencing slow bandwidth, please close any programs that may be running in the background. Feel free to use the public chat box to engage with each other. This session is being recorded and live streamed on the PLD India YouTube channel. This is an inclusive and safe digital environment. Intimidation and disruptions will not be tolerated. Participants who engage in disruptive behavior may be removed without prior notice. We thank you in advance for being respectful in all your interactions. A quick note on interpretation. French, Spanish, Bengali, and Nepali interpretation are available for these proceedings. To listen in French or Spanish, please click on the interpretation button at the bottom of your screen and select the French or Spanish channel. To listen in Nepali, please select the Chinese channel. To listen in Bengali, please select the German channel. If you have any issues with tech, please reach out to me via chat. Thank you. I'll pass this over to Madhu now.
Hello, everybody. A very warm welcome. On behalf of FIRE, I invite you to this discussion, which is in fact part of longer series of discussions. So let me explain a little bit about FIRE. The consortium, the South Asian Consortium, which comprises of PLD in India, BLAST in Bangladesh, Warwick in Nepal, Social Scientists Association in Sri Lanka, and AHANG in Pakistan, all of us working in collaboration with Asia Pacific. We came together about 2 years back to really look at the evidence around some of the laws, including child marriage, to see what the laws really, how they're playing out and affecting the primary constituency on the ground, which is young people. And the idea was to really make sense of what is the larger sort of discourse, both globally and within our countries, of repeated demands for more stringent laws, of declaring underage marriages void, and also what we have begun to see in the region and outside, the proposals to increase the minimum age of marriage to beyond 18 to young adulthood. It's 20 in Nepal, and there are proposals on the table and very likely may change to 21 in India. So in this context, we really wanted to ask ourselves the extent to which laws make a difference and what is the nature of their impact. And that's through this journey, which involved a lot of rich data collection, very exciting deliberations and dialogue between all the organizations as well as partner organizations within the countries that we expanded. Within each country, there were more organizations that joined, and you can see the collaboration right here on this panel. We began to initiate dialogue both within the region and with the CEDAW and the CRC, since they have a joint general recommendation on the issue of harmful practices, which includes child marriage. So here we begin the discussion, and we sort of, you'll hear what we have to say as part of this process, what the findings have been. And before I begin inviting the panelists, let me just introduce each and every panelist with us today. And I would invite everyone to put on their videos and kind of wave to identify yourself, so that everyone can see who is with us today. Before we begin, also let me share with you that we're extremely fortunate and privileged to have Ms. Gladys Acosta Vargas with us. She is the chairperson of the CEDAW committee, and Ms. Mikiko Otani, who is a member of the Child Rights Committee. Very warm, special welcome to both of you. And let me sort of move on to introduce the other panelists. There's Swagata Raha from India. She is the head of Restorative Practices Enfold Proactive Health Trust in Bangalore. She's also a member of the National Coalition Advocating for Adolescent Concerns in India. She has a long history of researching on issues of child abuse and juvenile justice. Swagata, welcome. Binita Pandey, who's a lawyer from Nepal. Binita is an advocate working with the Women's Rehabilitation Center, Warwick, in Nepal. She's a senior program supervisor and a legal coordinator. She provides free legal aid to victims of violence and to women from marginalized communities. There's Shahryar Sadat. Shahryar is currently the head of Program of Human Rights and Legal Aid Services at BRAC in Bangladesh. He's an advocate of the Supreme Court of Bangladesh and a mediator at the Global Mediation Panel of the Office of the Ombudsman for UN Funds and Programs. Welcome. Tehani Aryaratne is a feminist researcher working in the field of human rights and development in Sri Lanka and South Asia. She is affiliated with Social Scientists Association in Sri Lanka. We have Marissa Viana, who is from Brazil and is currently the executive coordinator of Research. Research stands for Realizing Sexual and Reproductive Justice Alliance. It's transnational feminist alliance grounded in Global South, working to realize sexual and reproductive justice. She joins here and will sort of help make the linkage between concerns which are very specifically South Asia with larger, broader concerns, making connections with Latin America. So welcome to all of you. And if we can sort of quickly just do a screenshot of all the panelists, so we have a wonderful documentation of us together. Yeah, have you got the screenshots? Yeah, thank you. The discussion itself, if I might explain, is structured along 4 questions. And I will ask these 4 questions and invite the panelists to come and present. Now, each question will have 2 panelists responding to it. And so I kickstart by asking my first question, which is, do strict laws prevent child marriage? 2 presentations will tell us how they worked in Nepal and Bangladesh respectively, and how do they impact lives of young people were caught within child marriage. We begin with Binita Pandey from Warwick, Nepal. Binita, over to you. You have 7 minutes.
Shall I start?
Yes, and can everyone close their videos so that we, have minimum disruption? Thank you.
Thank you, Madhu. Namaste, everyone. I'm from Binita Pandey from OREC. And on responding to the laws in Nepal, the strict laws in Nepal regarding child marriage, whether they are preventing it or not, I like to begin with the background. Like in the condition of child marriage in Nepal is well known to the global level, as UN has recognized it as one of the harmful traditional practices still prevalent in Nepal. And accordingly, the Nepal government has developed its national strategy to end child marriage by 2030. And it is in line with our commitment to SDG Goal 5, Target 3. So we can see child marriage in Nepal is a problem. However, government has tried to tackle it with various tools. Among them, law is one, and it is working as macro level intervention so that it can change the behavior of the people at the ground. And on understanding the Nepalese law, first I am just giving the background that it is strict in a sense that it has given absolute criminalization. And it is again strict because there is a strong commitment of the government from starting from its constitution itself, where it has provided rights to the children against child marriage. So it is very much a strong commitment from the government side. And on saying about the strict laws, it has defined child marriage as a crime through its state criminal code, which is very much general code and which is punitive in approach. So we can see if there is child marriage, there is definite a punishment is prescribed to the parties. And further, this criminal prosecution lead towards the non-recognition of the marriage of these people, as there is no legal validity of such rights. And in case of civil rights also, it is not available. The marital and family rights are not available to the married adolescent people. uh, so on analyzing it, so we can see that whether this strict law is really strict in a real sense, then there should be increasing number of prosecution of child marriage and decreasing the number of incidents of child marriage. However, in practice we find the situation is just reverse. I just like to give the example of a UN country team research in 2020, where it says that uh, they only could find during the period of 1996 to 2018, there were only 400 cases of child marriage being prosecuted or reported to police. Whereas in case of the prevention, before, Nepal used to stand at third position in South Asia, and now it is in the second position with highest number of child marriage after Bangladesh. So definitely this law is somehow not working. And on analyzing we can see its effect, then we need to see this law not only from the crime control approach, but from the social change aspect. And on that, we need to understand that this absolute criminalization of law interplay within the society in terms of inequality and power imbalance. And in Nepalese society, we can see there is caste-based discrimination, class hierarchy, gender equality, and the condition of the adolescent, which is regarded, which is seen mostly from the protective approach. So law interplays among these societal factors. And in conditions of the marriage, like even though it is from the consent of the children or adolescent, we can find during the prosecution, it is mostly guided by the revenge and retaliation of the family members, which is guided by their concept of honor and reputation, rather than the right based approach of protection and access to justice. So we can see it has yielded many unintended impacts upon these group of people, like it has unnecessarily dragged the adolescent to the criminal justice system just because they married of their choice. They married to the people of their choice when they both of them are of, when either one of them is of below of 20 years of age. And in this case of prosecution, we can see especially the boys are convicted. And ongoing deeper of the demographic data, we can find these boys are of a lower caste, and
2 minutes.
they are and they belong to the poor family. Meanwhile, on the other hand, the girls are also subjected to the violence. If they are subjected to violence and abuse in their in their uh, in-laws, then they cannot claim their legal rights, as law has not provided legal protection to such marriage. And in case where both married couple are living together also, they cannot access to the health services and other protection provided by the government to the married couples. So we can see it has increased the vulnerability among those already vulnerable people like girls, boys, and the adolescent. And this situation is also even noticed by this law, and its impact is also noticed in the report of a special rapporteur on violence against women, its causes and consequences. After her visit to Nepal in 2018, in the report of 2019, we can see she has said the existing gaps and inconsistency between the laws in child marriage are actually hindering the process of achieving SDG goal of Nepal. And she has further showed her concern that police rarely act to prevent child marriage or bring charges. So this is the real situation of this strict laws on child marriage in Nepal. And on concluding, I would like to say that we should not focus mostly on the prosecuting part. Rather, we should be taking the law as instrument for social change, so that we can move towards the positive direction and reduce the unintended harm in the society. Thank you.
Thank you, Binita. We'll move the same question. Shariar Sadat would be answering the same question, giving us a Bangladesh perspective.
Thank you, Madhu. I do not have any PowerPoint presentation, but I'll be talking on this child marriage law in our country. Before I start, I would like to draw attention to a couple of incidents that has happened recently. 7 girls who played at the national level football. And one of the girls became the best player at the national level tournament, has been married off when all of them are below the age of marriage, which is 18 according to our country's law. So that is one incident, and all 7 of them are coming from a northern district of Bangladesh and from a poorer background. Now, one point I want to make sure to convey to all of you, that there is no law which allows child marriage to be registered, but there is a law which is there to restrain child marriages. The law is known as the Child Marriage Restraint Act 2017. Now, this law is interesting, I would say, because there is an exception clause. Unlike other countries, there is an exception clause under Section 19, which allows that the children who are below 18 can be married off on 2 conditions. Number 1, there is a consent of the parents, and there is a court order. So if there is a special circumstance that the court says it exists, only then, subject to parental consent, there can be a marriage where the girl can be below the age of 18. Now, the law in our country is very much reliant on documentation. That means if you can produce the document showing that you are 18, no matter what, you can get married. So which leads to falsification of documents. That means the birth registration certificate and other certificates that is available, that can be falsified, and that has been used to make these marriages happen. Now, BRAC, we have done a quick assessment in last year's August. We spoke to 4,500 of our beneficiaries who took legal aid from us in 2017, 2018, and 2019. And we reached out to them to 298 upajilas of Bangladesh. And out of these 4,500 women whom we asked, that whether they were 18 at the time of their marriage. Remember one thing, these are the program participants of BRAC. They all had valid marriage certificate because they were all 18 according to document. But when we asked them that whether they were actually 18 at the time of their marriage, 82% of them actually told us that they were not 18 at the time of their marriage. So that actually shows the extent of child marriages in our country. Even though the law is there, but the heavy reliance on the documentation only, we are not being able to prevent it. So people can produce all sorts of documents like NID, birth certificate from their Union Parishad chairman, and they can get married. However, we have to also understand that the law has got its limitation, because the law is specifically looking at the liability of the parents, thinking that parents are forcing their children to get married. But there are two other scenarios that we have to understand, that young children, young people who are not yet 18, they're falling in love with each other, and they are also forcing their parents to agree to the marriage. And parents agree because they need to preserve their family's respect and prestige to the society. So that is a second scenario. We have to understand that parents are not really entirely responsible here. The third scenario is what we see, that elopement, that young people, they fall in love with each other and they go away from their families and they get married. Now, how these marriages are being held? In absence of proper documentation, these marriages are solemnized by the religious, all the religious formalities are being fulfilled, and they start living. Mind you, they do not have the registration given by the state because they did not have the documents. So it leads to another level of complication, where we see that these children, where they also, even though they got married, but after a year or so, when there is a problem in the married life, the husband leaves the wife now wants to have some kind of compensation from the husband, and if she goes to the court, sometimes court is saying, sorry, we can't give you any recourse because your marriage was not lawful in the first place.
2 minutes.
So that actually leaves that girl in a kind of a legal vacuum where she cannot get her dowry because it was not registered. And the most unfortunate problem can arise where if there is a child is born out of this marriage, there is a question of this child's identity, the question of this child's inheritance of property rights, and all these things are kind of in a quango. So the Child Marriage Restraint Act 2017 is there, but I doubt whether this is being really helpful to prevent child marriages. There are a lot of child marriages happening. Because of the COVID, the educational institutions have been closed almost more than a year now. So that is making situation quite vulnerable for children. And I'll end with my last incident. The last week, 6 young people, 3 couples were arrested in Chittagong. They fled away from their families and they were trying to get married, but they were arrested by the police, and the police contacted their families to take them back. So that's the overall scenario that we are experiencing in Bangladesh. I think I'll end my discussion here, and over to you, Madhu.
Yes, thank you. I think in terms of strict laws help, what we are seeing, 2 things emerge. One is in South Asia, and I'm sure elsewhere as well, there's very easy to falsify documents and get married anyway. Those who can't do that fall under the radar, maybe temporarily until the marriage breaks down for some reason, and then the women or the girls are left without any legal recourse because they have no legal status. they can't really assert any matrimonial rights. So it's making very little impact, as the macro data from Nepal shows. But which is then, begs the question: why is there so much emphasis being placed on law, and that too on strict law? But we move on. Take a step forward in our discussion to ask whether uniform responses or standard responses to child marriage is viable given the diversity of trends and contexts in our region and elsewhere. What other laws come into play? Even as we talk primarily about the child marriage law, what are the other laws that come into play in relation to child marriage, and what is the evidence of the impact on young people? I invite here Swagata Raha to present from India.
Thank you, Madhu. I have my presentation recorded. I hope it will be played now. In India, the law on child marriage, as well as provisions on statutory rape or sex with a minor, are predominantly used by parents to clamp down on early marriages being entered into willingly by their daughters. Studies have demonstrated that the Prohibition of Child Marriage Act is used twice as much against elopements or self-arranged marriages than it is used in relation to arranged marriages. In fact, it is rarely invoked to prosecute marriages being arranged by families. Contrary to the Committee on the Rights of the Child's recommendations to state parties to the UNCRC that adolescents should not be criminalized for consensual and non-exploitative sexual activity, India's approach has been one of blanket criminalization and stringent punishment. At least 20% cases being disposed of by courts under the Protection of Children from Sexual Offences Act involve girls in consensual relationships with their husbands or partners. While the men are arrested, the girls suffer detention in childcare institutions if they refuse to return to their parents and are compelled to stay there till they attain 18 years of age. Such institutionalization is justified in their best interest to protect them from an early pregnancy, marriage, or further abuse. This is ironic, as initial findings of a study underway on the treatment of 43 minor girls involved in romantic relationships reveals that the majority of the girls fled home to escape a forced marriage being arranged by their families after they found out about their relationships. Many girls were also in intercaste and interfaith relationships and had eloped with their partners out of fear for their lives or to escape the violence that was being perpetrated by their families. The experience of the girls in these childcare institutions has been one of humiliation and alienation from their partners and the outside world. Their education is disrupted, and the system inflicted trauma aggravates their mental health and well being. There are barely any vocational training or educational opportunities available in these facilities, and under the guise of protecting the girls from an early marriage or pregnancy, their liberty and dignity is routinely undermined and overall development is stunted. We are also witnessing the counterproductive effect of the laws on the barrier-free access of adolescent girls to health services and social security programs, something that is essential for them considering that majority of them are socio-economically vulnerable. The POCSO Act requires mandatory reporting of sexual offenses against children and adolescent married girls seeking treatment, abortion, or any other social security scheme for pregnant women, all of whom incur the risk of a criminal case being lodged against their partner or husbands when they approach healthcare providers. Anecdotal accounts suggest that they do not return to hospitals for reproductive health services when they are informed by doctors about their obligation to report to the police. Given this situation, the Indian government's plan to increase the age of marriage for girls from 18 to 21 years is alarming. In Karnataka, an Indian state, child marriages have been declared void ab initio. Automatic invalidation of child marriages disproportionately impact the female party to the marriage and children born of such marriages, as it legally allows men to walk away and deprives women of their matrimonial rights. We need to take stock of the significant harm such laws are already causing to the very group they seek to protect and recognize that proposals to increase the age or make child marriages void ab initio will aggravate the vulnerability of adolescent girls and push child marriages underground, something that we are seeing during the pandemic. The assumption that early child marriage can be addressed squarely through legislative reform is flawed. Investment needs to be made in community based mechanisms to effectively enable the translation of constitutional norms on dignity, liberty, privacy, and best interest through creation of safe and inclusive spaces for open, sensitive, and difficult dialogues among children and adults about sex, gender, sexuality, equality, identity, consent, autonomy, power, and violence. To advance protection of children and adolescents, positive enabling legal provisions that mandate the introduction of comprehensive life skills and sexual and reproductive health education programs within schools as well as communities need to be introduced. Socioeconomic policies and programs should be designed to ensure girls are not pushed out of schools, meaningful employment opportunities are created for adolescent girls, and families don't fall out of the safety net due to the economic shocks caused by COVID 19. Thank you.
Thanks, Swagata. I'll invite Maliha Ziha from Legal Aid Society, Pakistan. She is going to be presenting on behalf of her organization as well as AHAN. Over to you, Maliha.
Thank you so much. Sorry, just give me 1 second. I'm putting on my screen, yes. So in Pakistan, we have a series of laws that respond to child marriage, much as the same way in Bangladesh, thanks to the history that we do have. Can you go on to the next slide, please? So to give you a brief snapshot of what the laws look like, we have laws relating to child marriage, which, sorry, Nadia, could you go on to the next slide, please? Yes. So we have different child marriage laws at the federal capital and at the provincial level. And then we have, therefore, we have different standards and minimum standards of all things. So for example, in the federal level and in 3 of the provinces, the age of marriage is 16, while in Sindh, the age of marriage is 18 for both boys and girls. Yet the courts continue to use age of puberty as a determinant for adulthood and child marriage. The status of child marriage remains valid. So whether it is punishable, but still remains valid, requiring a divorce or dissolution, which is only allowed if the marriage has not been consummated. The people who are punishable under these laws, which is uniform across but different punishments, is the adult male husband, the parents or the legal or illegal guardians, and the person solemnizing the marriage. Additional laws, such as in the Pakistan Penal Code, declare all other sexual intercourse punishable, which is either fornication or punishable as adultery. And if any kind of sexual intercourse with a girl below the age of 16 is termed to be rape. Next slide. Has the law been successful? It has not. Pakistan remains the 6th highest country in the world with child rights, with 18% of girls being married before the age of 18 and at least 4% being married before the age of 15, as per UNICEF reports. So the numbers remain quite high. Next slide. And this is also, keep in mind, the reported numbers. And as mentioned earlier, many slip below the radar as well. Now, whether laws are failing to consider the nuances of child marriage are the different kinds of child marriages and the different kind of situation that surround child marriages. For example, voluntary child marriages when the contracting parties are close to age. The social norms around child marriages and the reluctance to even report child marriages in a patriarchal system which is in favor of it. The economic reasons that support or discourage child marriages, and whether the marriage will be void or voidable itself. There are many cases in Pakistan which has a large number of refugees where marriage is done to secure identification or citizenship. And it even fails to consider the notions of pedophilia and or rape in many of the cases that come forward. Next slide. So the sole focus on age has proved to be largely inefficient and insufficient. The inconsistency between the federal and the provincial level and what is done in court is still very different across different laws. So rape law, which is a federal law, says age of consent is 16. The marriage law says 16. In the provinces, in Sindh, it's 18. In other laws, it's 18 to define as juvenile. So there's a lot of inconsistency of what is the age of the child. In cases of forced marriage, it is 16 as well. In rape, it's so there's a confusion between the federal, provincial level and what's happening in court, which results on focusing on age as the only reason and the only way to identify whether an offense has been committed as something which is faulty and confusing, and leaving a lot of gaps and space for those who support child marriages to be able to use it and misuse it and make sure that legal cover is given to these cases. Issues relating gender and power and control over women's sexuality and body are ignored by policymakers and lawmakers. We cannot hope to actually address the underlying issues of child marriage purely just by law. And this is exacerbated by the situation where the courts focus on the age of marriage as age of puberty once the cases are before them. Because in many cases, there are cases of elopement, or there are cases where the girl is being forced to say she's eloped or that she's overage, and they let that pass using age of puberty as a justification. Next slide. Additionally, there's a lack of protection systems. Frankly speaking, there's absolutely no proper protection system for girls. They look at the way the Darul Aman, the shelter homes where women victims of violence are placed, and that is where the girls are sent until they reach the age of 18. So many of the judges ask me very often, they say, what are we supposed to do with them? We have three options. One, we send them back to their parents, but we don't know if the parents were involved, not involved. Would they be victims of honor killings? What other violence would be inflicted on them? We send them to their supposed husband, who may be adults, but now she's being raped or she's being violated, or any other kind of issue that she might face. Or we send them to the shelter home with other victims of violence until she reaches the age of 18. Those are the only three options that we currently have. So we have to start looking at larger protection systems on how to help all of these girls. Next slide. And penalization has proved to be an insufficient long-term solution. It has, as you can see with the numbers, has not succeeded in being a deterrent. It has not even affected the social acceptability of child marriage.
2 minutes.
It also allows that sympathetic judgments being reluctant to give higher punishments. So the higher the punishment, the more reluctance of sympathetic judges to find them guilty. Being liable for fornication, if not validly married, increases pressure on young girls to say that they are actually adults and support child marriage. The increased penalization also gives more power to perpetrators and men by controlling girls and women, by manipulating and misusing the law. In many of the cases, child marriages did end up being cases of elopement. In many cases, of course, they were very much victims of violence, but it also makes it murky, the ground between victimization and empowerment. So victims are being made to believe that they are elopers or have transgressed societal norms, but we're not being recognized as victims of child marriage when an underage girl is being raped by her husband, legal, and I say that in quotes, quote unquote husband. And therefore, it cannot focus on the on-ground realities. There's no alternate punishment. There's no sense of damages. There's no sense of community work, anything else. It cannot focus on the complication in cases. And there's a lack of focus on the impact of child as a whole, whether forcing her to go through court and the entire court system, or whether forcing her to come into an open court and talk about who she wants to be with and all the complications. It is not as easy as black and white, and it's not being able to respond adequately to the realities that a child faces and the impact it has on her. Next slide. So the recommendations, of course, there are many. We're starting off with revising all laws to ensure consistent age. Age of puberty must be clearly revoked. The marriage itself must be made voidable, allowing for a choice and decision-making of the child itself. The rules and the laws must be amended to differentiate between the different kinds of marriages contracted, whether it's a slightly older child, 16-year-old marrying an 18-year-old, or between partners of young age. The interlinking laws must be amended to make sure they're consistent, and laws against pedophilia and child sexual abuse must be strengthened. Next slide. And all the other factors of birth registration must be made low cost and made compulsory. There must be increased community awareness, increased contraceptions, And there must be efforts of prevention, which includes life-scale sexual education, and lastly, an effective child protection and welfare system to provide long-term support to these children. Thank you.
Thanks, Swagata and Maliha. I think what's absolutely striking is that child marriage, the whole issue cannot be discussed in isolation. What's happening is that across the region, in each of the countries, there's a significant trend in elopements. And remember these are all countries where female sexuality comes with a lot of taboos and restrictions, and any transgression can invite honor crimes and honor retaliation. So it is a context where both the issue of child marriage is deeply embedded in issues of age of sexual consent, which in countries like India, adolescents have no legal capacity to consent, or in countries like Pakistan, where there's no possibility of consent outside of marriage, and consent inside of marriage is understood to be compulsory. So it is actually embedded in issues that are much more complex, that of honor crimes, sexuality, of sexual health, of accessing sexual health services safely, of issues of poverty, minority status, and the whole issue of conversions that Pakistan has alluded to. So it's hardly a context where we can afford to talk about child marriage laws in isolation. And what is noticeable is the staggering levels of criminalization of elopements through the stringent child marriage as well as the sexual offences laws. And this should actually worry us a bit, to go beyond the lip service to unintended harm and consequences, to actually make the front and center of our interventions there to address those harms and consequences. But let's move on to our next question, which is assuming for a moment that we have child marriage prevalence rates dip very successfully, as they do in some countries. Is the dip in child marriage sufficient evidence of having prevented early domesticity of girls and early childbearing for girls? And is the low prevalence of child marriage a sufficient indicator of success, or does it conceal issues of girls' sexual and reproductive health rights? So I invite Tehani to present from Sri Lanka.
Thanks, Madhu. Mrinalini, could you please share the presentation? Thank you. First slide. So the answer basically to the questions posed by Madhu is no, based on Sri Lanka's experience. Laws and legal approaches are not nearly adequate to address some of the concerns around underage marriage and adolescent SRHR. Next slide. To briefly look at the laws governing marriage and sexual consent, the age of marriage for all communities except the Muslim community in Sri Lanka is 18. For Muslims, they are governed by the Muslim Marriages and Divorce Act, and there is no stipulated minimum age of marriage there. However, girls under 12 years of age require permission from the Qazi to be married. The age of consent is 16, which recognizes the evolving capacity to consent. And the age of consent for Muslim girls effectively is 12, because there's a law around it, which I will not get into. The law does not prescribe criminal punishment for underage marriage. However, what it does do is it criminalizes presenting false information to the registrar, which is what people do in order to register underage marriages. Next slide. Just looking at the prevalence and trends again briefly, Sri Lanka has a low prevalence of underage marriage compared to other countries in the region. As per our 2012 census, the average age of marriage was between 22 and 24 years across ethnic groups. So we could say that underage marriage per se is not a pressing concern. However, there is a higher prevalence of underage marriage in certain pockets like rural and or war-affected villages, the estate sector. There are urban and semi-urban pockets across the country where we do see underage marriages, as well as in the Muslim communities. Um, Factors like conflict, poverty, social marginalization can create circumstances where families and or adolescent girls are pushed into situations of underage marriage for physical, social, economic, and other security reasons. Next slide. Sorry. No, however, okay. The available data, however, indicates that the age of marriage was already on the rise in conjunction with the introduction of free education in the 1940s. When the minimum age was raised to 18 in 1995 through amendments to the gender marriage law, the average age of marriage was already well above 18. So I think, therefore, what we could say is that not merely a law on underage marriage, but access to socioeconomic variables like education, healthcare, employment opportunities are all important aspects in preventing early domesticity, because they do provide options for young women besides just marriage. Next slide, please. However, I think the caveat to this is the MMDA, because there is no minimum age of marriage under this law, and this does create a context of increased vulnerability for Muslim girls. There are documented cases of marriages at 12 and 13 years across districts, but on average, the majority of underage Muslim marriages are between ages 16 and 17, so still kind of well below the minimum age set for all the other citizens. And this creates, an increasing, like a very vulnerable context for young women, because they have no say over if, when, and who to marry, and their health, education, employment, and other factors of well-being are impacted. There have been calls for reform from activists to make the minimum age 18 without exception, in keeping with the general law that impacts all communities. In this case, it is imperative that the state brings in a minimum age of marriage, while also recognizing that a minimum age is only one step towards creating an enabling context for the full enjoyment of rights for Muslim women and girls. Next slide, please. So looking at rates and incidence of child marriage is not adequate to understand how the state and society is responding to adolescent sexuality. Cohabitation is a trend we are seeing in Sri Lanka, where adolescent girls and boys who are in a relationship live together until they both reach the age of marriage. This is either by choice. I mean, in our field work, we did find many cases where they wanted to live together, but there are also cases where they are compelled to or forced to by their parents, and in some cases also local government officials, particularly if they are known to have engaged in a sexual relationship or if the girl is pregnant. These kind of de facto marriages are seen as a way to maintain the honor and dignity of the individuals and their families. In these situations, we often see the girls dropping out of school, or if they're pregnant, they're asked to leave school, which has detrimental impact on their education, employment, and overall well-being. Cohabitation appears to be socially accepted, of course, though not preferred, but there is kind of in our fieldwork, again, there was this acceptance that, yeah, they will live together until they get married. And this is often the method through which families and local government officials choose to deal with the problem of adolescent sexuality, particularly the gap between the age of consent, which is 16, and the age of marriage, which is 18. And many officials refer to this as a problem, like, what do we do about this? This is the only way we can address this. Next slide. So, I mean, the issues surrounding this idea of underage marriage are rooted in societal understandings of sexuality, consent, and sexual agency. But largely there is stigma around sexual expression outside the framework of marriage. And it creates a context where youth are not able to make free and informed decisions about relationships. They may be in a relationship at 16, they are forced into cohabitation, and then they may be compelled to marry at 18. So it does it creates a context where they are forced into also long-term relationships when they might not want one. So there is kind of an urgent need for state intervention to ensure, on the one hand, compulsory comprehensive sexuality education, but it's also imperative that there is a positive discourse around adolescent sexuality, particularly for young women, which centers their agency and decision-making regarding their bodies and sexuality. It's not just laws and policies, but social perspectives need to be shaped to respond in a way that protects and empowers adolescent girls while they're able to enjoy their full rights.
Time's up.
To sexuality. Thank you.
Take a minute if you need to wind up, Dehani.
No, that was actually the
okay.
very end. So it was
Okay.
fine.
Okay. Thank you. We'll move on. So clearly what we are seeing is that cohabitations are flourishing where the or de facto marriages do sort of occur, where the rates of underage marriage might be seemingly low. I'll ask Marissa Viana to join us and to present. She comes from Latin America, and I think that perspective would be very valuable to see to what extent it dovetails with the South Asian one, and how does it play out really in your context, Marissa?
Hi, everyone. Thanks so much, Madhu. And thank you so much for inviting me to share this space today. I am going to try to give a little bit of context on this issue for Latin America, but obviously there is a lot more that can be discussed, and I apologize in advance for some of the issues I won't get to. But in the context, so I think similarly to Tehani, the short answer is no. It hasn't really sort of addressed or changed the context in which adolescents and adolescent girls are entering cohabitation, and also hasn't impacted childbearing. In the context of Latin America, the issue of early unions has persisted for years. And I think there's a word here around methodology in terms of not perhaps in Latin America, the terminology not being as common. So not existing as a child early enforced marriage, but as early union described as informal unions and cohabitation practices. Despite the fact that in Latin America, 1 in 4 girls marry or enter unions before reaching the age of 18, child early enforced marriage is still generally not formally recognized as a big issue in the region, in particular because so many of these unions are understood to be consensual. So we are looking at a situation where while prevalence is actually high, given the documentation and research done not primarily by government, but NGOs and other institutions, these unions are not legally registered as marriage. So therefore, there is also an impact on public policies and programs in addressing this issue. So generally, in terms of the legality, it's illegal to get married before the age of 18 in most of Latin American countries, with some exceptions varying from country to country, where you can get married before the age of 18 with parental consent or court permission. An exception, or an interesting exception, is Honduras, where the age of contracting marriage is actually 21. And in 2017, it passed a decree that eliminated all exceptions for marriage below the age of 18. But I would say that this has little to do with protecting girls or creating an enabling environment where adolescents can thrive. In particular, if we look at how Honduras has undermined and violated women and girls' sexual and reproductive health and rights, including by criminalizing and imposing a total ban on abortion, the total prohibition of emergency contraceptive, even in cases of rape, the absence of sexuality education, and little to no contraceptives, and a high rate of birth by girls 10 to 14 years old. So we can also see here the contradiction between setting a really high age for marriage and have this trend of like no exception, but yet all other social issues and that comes with bodily autonomy and sexual and reproductive health and rights is completely banned or criminalized. Other countries in the regions have also recently passed laws of no exceptions for below the age of 18, including Costa Rica, which passed a law in 2017 called improper relations in English. It's called improper relation that prohibits marriage of persons under the age of 18. Ecuador also passed a law in 2015, Guatemala, Panama, and Brazil changed the civil code in 2019 to ban marriage under the age of 16, which until then was allowed to escape rape charge or if the girl was pregnant. So I think a note here just to say that none of these changes in the recently is a coincidence. All of these also align with the SDG's targets to eliminate child early and forced marriage by 2030. LAC is also, Latin America and the Caribbean is also the only region that has not seen a decline in child marriage over the last 25 to 30 years. In Brazil and Mexico, for example, with a large population of being young people, adolescent girls are the most impacted. This is also and making the link here with sexual reproductive health and rights is also witnessed by the high number of pregnancy and childbirth to adolescent girls. In Brazil, for example, 1 in 7 births are to adolescent girls, and the majority of these pregnancy being unplanned, and reportedly one of the main causes to end early marriage. So in this context, the focus on a legal age of marriage is the parameter of to respond or prevent early cohabitation and childbearing. There's little to change the reality of adolescent girls. So I just want, just in terms of the prevalence and being the indicator of success, I think we need to talk about where the issue of where informal marriage or unions are as common as they are in Latin America and the Caribbean, after happening before the age of 18, the trend of no exception law on child early and forced marriage simply reinforces the disadvantage of girls in informal union, in particular in rural and indigenous community and young women and girls living in poverty. Often these laws focus on age as the main vulnerability, disregarding the adolescent's autonomy and evolving capacity. And my last point here is that it also further marginalizes adolescents and young people that enter consensual unions, marriages. I think the hardest reality for a lot of those of us working around these issues and trying to come up with ways of addressing it is that a lot of adolescent girls who are 16, 15, 17 are entering these unions consensually. There's a desire to get married, to have sex, or to justify having had sex, as well as need to leave an abusive home. It often opens doors when it comes to access to sexual and reproductive health services, or because it's an available life project where getting married is a way to gain status in building a life of their own. These are all aspects of the context of child early and forced marriage that do not factor in the strict legal framework where it focuses on age of marriage alone. I'll stop here and I hope we can get to more of other questions and other issues during the Q&A. Thank you.
Thanks, Marissa. I think what is emerging is this kind of overwhelming focus on age that is sort of displacing so much else that is at stake for girls. And with this, I'll go on to the last section of this discussion, which is to get concluding comments from the two experts who are with us. I would also like to sort of pose to them, the comments can be quite broad, broad, but if possible, I would like to hear that in light of proposals in South Asia and elsewhere to increase the minimum age of marriage to young adulthood to 21, we no longer, the word child marriage is no longer relevant. We are talking about underage marriage strictly. And there is an emerging trend of aggravated harm to young people who are being institutionalized. What would be your guidance and suggestions in light of the joint general recommendation on harmful practices to address this issue, which is, there's no overwhelming evidence indicating the issue of harm to young people. So would like to hear from you. And let me first invite Ms. Acosta Vargas. Ms. Vargas, I have to apologize that we would rather hear you in English because our interpreter cannot switch from Spanish to English. She can do the other way around. So yes, if it's not too inconvenient, we'd like to hear you in English. Thank you.
Well, thank you very much for this invitation, and it was very interesting for me to listen to you and to understand better the complexity of these laws that in principle should protect girls from early marriage. But I see clearly that in many cases it's not enough to have a law, and because this is not just an issue of the content of the law. I think that we need to connect the law and the reality. And here we can see clearly that there is a disconnection or a pervasive connection, if we can say, between the objective of the law and the reality for girls. And I think that this is what we need to take into account when we talk about international standards, because the international standards are never only one, only the age in this case. Of course, we can see, and my colleague from the CRC will explain better than me, that it's the 18 is a kind of threshold, because we consider in CEDAW, and I think in the CRC too, that there is no conditions before 18 for women to take responsibilities, the kind of responsibilities that are in a marriage, because these responsibilities are in contradiction with their own lives decisions many times, and they cannot continue to study. For example, the right to education is so important for women. If they don't have education, their future for work, for opportunities for work, the opportunities for independence, economic independence, autonomy in their lives, for decisions, so important decisions as, for example, having a family. These kind of things decisions need to be taken by them, but with the help of an enable environment, which is in our analysis and for the international standards, it's exactly the right to education. The protection around girls is so important for their own decisions. And of course, in education, we need to have sexual and reproductive health information, because it's girls, they don't know what is happening with their bodies. They don't know what is happening with the sexual relationships. If they don't have freedom in their life from the very beginning, they have to learn little by little. The evolution is going into freedom. It's not going into more the limited life like in marriage. They need to grow and to make an evolution in being girls and being adolescents, and decide little by little. And the family and the community and the educational environment need to help them to make these decisions. And I think that what I'm listening now is that instead of giving girls this environment for decisions, they are really taken as property of the family, property of the state. No, and this is not acceptable. This is my first, I think, comment, and I can understand, and I'm really glad that many studies are going into details on how the law is applied and how the law is not protecting girls, even boys, but the law is protecting a patriarchal power in the family and in the states. Thank you very much. I'm ready to continue with the discussion with you.
Thank you. Thank you. We'll look forward to more questions. I'm sure they'll be posed to you. Meanwhile, may I ask Ms. Otani to comment as well?
Thank you very much. First of all, I'd like to thank the organizers to invite me to listen to all the presentation, which is very, very informative and powerful. I want to make some comments because the joint or general recommendation of the CEDAW and the general comments of the CRC, we have been taking the child marriage issues very seriously. But I was very struck by hearing all the presentations, because we always ask the state parties to of course, enact law, because for us, all the appropriate measures, we often think that law comes first, and then implementation, effective implementation, and policy and education. But we ask the state parties to enact the law and monitor and assess whether the law is effective or not. So now we are hearing that always the committee requests the state parties to establish the minimum age of marriage at the 18 and implement that law. But now you are saying that this kind of approach, simply focusing on the age, is not helpful and actually marginalize the girls, in most of the cases, girls, and make young people more vulnerable. So you are now telling us that you, as a civil societies, studied the outcome or the consequences of the laws, focusing on the age, and it's not helpful. So it's a very strong warning for us to approach the child marriage issue in a much comprehensive way, and to understand from the children's perspective what should be the alternative, more effective approach. So I really appreciate, and I just want to share with you that in the committee, as I said, that we actually always request the state parties to take legislative measures, such as establishing the minimum age at 18, or if it's lower, then raise the minimum age, or if there are the exceptions, we always ask the state parties to abolish such exceptions. But when we find that even after the state parties take such legislative measures, still the prevalence of the child marriage, we very often request the state parties to take all the appropriate measures, including the awareness raising, strengthen the awareness raising. However, I understand hearing all the presentations made by the previous presenters today that asking the strengthening the awareness rating itself is not enough. You are telling us the child marriage is more complex, and the different types of the child marriage have to go deeper into the realities and understand the root causes and what kind of child marriage are actually happening. So I really want to what I have heard today bring into our practice of the dialogue with the state parties. And in response to the question from Madhu, so what should we do? Because now, as you said, that it's no more the issue of child marriage, but rather underage marriage issue. And also the young girls are sort of institutionalized. And so I think, again, we need to address these issues from the broader concept. And we, the Committee on the Rights of the Child, always think that it's a very sensitive issue, I would say, how to balance the protection and recognition of the evolving capacities of the young people. So the age of 18 is cutoff age for our convention, but all the individuals go through the childhood stage and going to the adolescence and go to the adults. So this is the 18 is a kind of age, but we need to understand this life stage in a much more comprehensive way and think about the child and the young people and their experiences and their agencies and their voices to be heard. And so this reality pose the questions for us to study more about the reality, what is happening on the ground, and how to address these issues in a much more comprehensive, effective way. And I think perhaps that we should work closely together with the CEDAW committee because it's not the children's issues only, but also the young women's issues as well. Thank you. I'll stop here, but I will participate in the question and answer. Thank you.
Thank you. I think your comments have been so valuable, especially the point that Ms. Acosta makes about the fact that the laws have empowered patriarchal powers rather than the young people themselves. And the point that Ms. Otani makes about what about giving voice to the young people. And I think the problem that is emerging for us is that no exception laws model, which is globally being promoted, actually takes away the voices of young people. They have no say in the matter. And also that really it doesn't really comprehend the diversity in trends. You know, there's everything from trafficking to forced marriage to elopements that's happening and everything in between. So I think that's the kind of dilemma that we have with one model, which is it just doesn't fit every situation. So I'll ask Nadia to read out the questions. And those who want to respond to the questions, please sort of show your hand from the panelists as so we can sort of quickly direct the question to you. Yes, Nadia.
Sorry, Madhu, just 1 second. I'll start with a question from Preeta, who's asking, all panelists, what provisions exist in the country for separate legal representation from children and adults in theory and practice? I see that a couple of people have answered, but if anybody else wants to take this.
I think there's also a question before that on trafficking.
Yes, I think someone is asking about a comment on the issue of girl-child trafficking under the guise of girl-child marriages.
Sure.
Could you please repeat the first question?
Sure. That's a question about provisions, is that right?
Is provision?
Yes.
Yes,
So the
legal
question is,
provision. Yeah.
yes, what provisions exist in each of your countries for separate legal representation for children from adults in theory and practice?
I think it would be useful if if that could be answered in the box, because I think Bangladesh has. If somebody wants to quickly come in, please do. And the question on trafficking.
Okay. First of all, I really would like to talk a little bit about the voices of young women, because legal representation also is connected to that. And I was looking for what would be a kind of transition between what we have now and the future. Because of course, we cannot come back to a situation where there is no limit for age in marriage. We cannot go, to that stage. We should continue to promote that marriage should be for adults, not for girls. And this is why we set 18 years old. But the question here that we need a kind of transition, and what I was thinking, I was making a parallel with the juvenile justice and thinking, I worked a lot on juvenile justice when I was working with UNICEF. And it was clear that judges in the juvenile justice was really providing a lot of help to young men and women that were in conflict with the law. I think that we need here judges that could help girls that are trapped in this situation of marriages that are in fact a kind of restriction for them, instead of being something that it's a decision in their lives. And my feeling is that this idea of legal representation of women, of girls only in parents is not enough, or parents or the person who is taking care of them. But we really need authorities that are taking care of the interests of girls. And this is something that we need to begin to think about it, because we were always thinking that specialized judges could help in these situations. And we need to find a place in the state where to go for girls to complain, where to go to be protected, but not to be institutionalized, as you said, but to be protected, really legally protected. And this is something that I really think that we need to think about it. And we need to, what we need to promote is that girls should have the right to education, to health, should be really protected. And education in a broader sense, including sexual education, including access in health to contraceptives, including access to abortion services. We cannot only take one part of this problem. I think that we always need to see the whole picture, and between CEDAW and CRC, I think that the international standards are there, but we need to find ways to be more clear and more proactive, asking state parties about this and discussing this with civil society organizations too. And regarding trafficking, of course, this must be a relationship, but I don't have enough information, but we need to look at that. We know that one of the forms of trafficking is forced marriage. Then there is a connection between forced marriage and trafficking. Thank you very much.
I'm going to jump in here at this stage. There are some questions, but also ask Swagata, given that you've looked so much at the law, have you come across any cases of trafficking being prosecuted for young people? Because certainly in PLD's research on child marriage, we didn't see a single case of trafficking being prosecuted. It was mostly elopements. So from you, yeah, just to understand, there are different trends, but in prosecution, we are tending to see one kind being prosecuted more.
Absolutely, Madhu. That has been our experience with the data that we've looked at. Majority of the cases that are entering the system under, say, the Prohibition of Child Marriage Act or the Protection of Children from Sexual Offences Act are of the kind where the girls themselves have left home willingly with a partner of their choice. So we have not, and we've looked at over 2,800 cases. We did not come across a single case of trafficking. And having said that, the implementation mechanisms are also fairly weak in the context of trafficking. So that's not to say that trafficking does not take place for child marriage, but it's just that the system is not efficient enough to prevent it or to even redress it when situations like these come to it.
Yeah, thank you. You know, that's the concern we are having. I mean, to the person who asked the question on trafficking and more broadly to everyone, that trafficking is definitely happening, but the access to the legal system is usually by those who are in power. And we find that parents prosecuting young, their eloping daughters' husbands is the biggest emerging trend. And that's troubling. You know, trafficking is not going to be not visible in the prosecutions. And it just goes to the heart of the point we're trying to make. Can one approach, which is a zero tolerance approach or a no exception approach, be relevant for all forms of marriage? Some of them are going to be under the radar. The ones who get caught, we've already heard. There's a question from Audrey Lee to the panelists. Actually, she has a question to Ms. Acosta and Ms. Otani specifically. What she's asking is, Audrey is from Euro Asia Pacific. You're familiar with her. She's asking is, what are the upcoming opportunities for treaty bodies to strengthen their approach on child marriage through the drafting of the CEDAW General Recommendation on Gender Stereotypes? If there are ways the committee can address the issues of root causes of child marriage due to conception, stereotypes that marriage confers status, protection for girls against SGBV. Her second question is that to their approach in the guidance note on COVID, reports of higher incidence of child marriage already known widely, but what are the strategic entry points for CEDAW and the CRC that they want the states to focus on how CSOs can supplement these actions, resources, awareness? This question is in the chat box. It's a very long question, two of them. Please do look at it, and I'd like to hear what you have to say. Yes.
Okay. First of all, about stereotypes. As you know, we are now beginning to prepare a general recommendation on the rights of indigenous women, probably the next general recommendation would be on stereotypes. And the stereotypes is more and more, I think, important. And we are really, of course, when we ask state parties, we put together in general stereotypes and all forms of violence against women. And of course, we are talking here about the part that is violence against girls. And then stereotypes is really a key element to understand and to tackle this issue. And it is also clear that for girls, one of the main issues here is education, because the educational system could really work on the stereotypes. But we need to be sure that in the curriculum, there is not only sexual education in the sense more related to health, but we need to be sure that the education system is also tackling the stereotypes in the lives of girls, and they need, otherwise you cannot open the discussion and open the right to freedom in sexuality. And I think that here it's stereotypes and sexuality are connected, because the stereotype is the sexuality controlled by men. That's why I think that sexuality education in sexuality is so important for girls, because it's here when girls could live sexuality differently. And when I am saying girls, I think that we also need to be clear that in the international standards, it's not only adolescents that are have sexuality. I think we need to really respect the right to sexuality for children, and the adult world and the family should protect children from the very early age to have a sexuality in a very healthy way, understanding and be respected in their body and the way that girls and boys discover their own bodies. And this is something that I think that part of the problem is the silence, and the silence is conducting to abuse in general, to abuse sexuality of children and adolescents. That's why we are really focused on this educational part, formal education, and of course, education in the family as in the communities, because otherwise there is no solution for this end in marriage. We don't want this end in marriage. Even if girls would like to have a sexual experience, they should have the right to have sexual experiences without not being married. This is the point, that marriage is not for women, should not be the only way to live sexuality. I know that this is really controversial, but the freedom of women begins when they are girls. And of course, with COVID, many of the forms of violence against women and girls has been exacerbated, and we need to discuss very deeply with governments and with the state parties about the protections that are needed much more after and post-COVID, but in the middle of this pandemic, because we don't know that how long this will stay there. Then we need to begin to express the need for more protection for girls and for women during these times. I really would like to hear from Mikiko. She is much more knowledgeable than me on this point. Thank you very much.
Yes, Ms. Utani, we'd like to hear you too. Yeah.
Yes, thank you very much. I want to start in response to the previous question and combined my answers to the question from Audrey. Previous question was about the legal representation, and now one of the topic here today is the unilateral, the unified, the simplified approach with no exception is not working, and what would be the alternative effective way to prevention of the child marriage. But I would like to address these questions from the what could we do after the child marriage is happening? Because I pointed out the committee has observed in many state parties, despite the Child Marriage Act, which established the minimum age at 18, but still the prevalence of the child marriage is high. So now I think one important aspect to address this situation is to understand the situation from the children's point of view. We call the child marriage harmful practice in our general recommendation and general comment. But when the children are considered to be the victims, instead of giving them the opportunity to participate and express their views in the process of remedy situations, or providing them the access to justice and supported by the legal representation or the their own lawyers, we again address this situation in a paternalistic way. As Madhu mentioned earlier, institutionalize children or sort of lock up the children in a shelter or send back to the parents. So I think the one of the entry point or opportunity for our Committee on the Rights of the Child to address these issues in much broader way, taking into the consideration of the child's perspective, is the access to justice. Because the committee has been discussing about the access to justice issue recently, but what would be the remedies? What would be the justice for those children? So, and also if the criminalization or punitive approach actually punish the children, how those children should be protected by such unintended consequences of such law. So I think this would be one of the entry point for our committees discussing these issues, and also the civil society to inform us what is happening on the ground and how we can think about this issue from a different perspective. In terms of the COVID-19, I think this is another entry point because as the Audrey already pointed out, we have been aware that child marriage is increasing under the COVID-19. Recently, the treaty bodies are planning to organize the sub-regional or regional webinar on certain issues, the impact of COVID-19 on human rights issues. And this is the inter-committee activities and a new initiative by treaty bodies as a system, not by just one committee. So again, this would be a good entry point for us, Committee on the Rights of the Child, together with the CEDAW or other committees, to think about this child marriage issue, not just focusing on the age, but thinking about the root causes and a more individualized understanding. And as Madhu said, that you are saying that totally, very vocally, that one model doesn't fit for all. So how in region or in sub-region we can learn from the actual situations from each country and think about together as a regional approach, or sometimes like today, we learned from the situation in Latin America. So within the region or sub-region, but also across the region, we can learn each other, and we can more deeply discuss this issue in relation to the COVID-19. So as far as we have more information, I want to share, but the first issue to be taken for this sub-regional or regional webinar in relation to the COVID-19 is mental health. But this is just one issue which has been already decided to be taken up, but we can propose other issue which would be suitable to discuss between the committees, but also together with the CSO and with the state parties in the region. Thank you.
Hi, Nadia, could you ask other questions that have come up, please?
Sure, Madhu. I have a couple of questions relating to the question of protectionism. One from Audrey, asking about how does the institutionalization of girls, survivors of child marriage that is, sit with our understanding of a victim-survivor-centered approach to SGBV? The situation can't even be excused as protectionism, but it's just state violence. In a similar vein, Susanna Freed from Korea says, it seems to me that part of what I'm hearing is the importance of interrogating the rhetoric of protection. Who are these laws protecting? As Ms. Vargas states, is this about protecting property and patriarchal power? If so, how do we explain human rights norms and standards that are also advancing such, quote, protective laws?
You know, I would like to answer this. Protection is a very difficult word. You can hear protection as control, and you can hear protection as really an environment that is really thinking of the rights of girls. And I think that the pervasive thing here is that protection is in many times, worse than the situation that girls were living in. And this is the case of institutionalization in general. I don't know any good experience on institutionalization of girls. In general, it was more connected to control of their lives. And I think we need to be much more creative. Maybe the notion of the kind of shelters that are in the hands of the community, instead of shelters that are or centers for protection that are, I would say, even like with police, because the idea of control is so incredible and so strong that for children and for girls specifically would be really like a prison instead of being a place for protection. And that's why I think that the notion of what is in the Article 12, the notion of the voices of children, is so important for institutions. And the issue is we need to understand what they are thinking on the matters that are affecting them. And this should be part of the institutional work for the state parties. They should have institutions that ask that listen to what girls are saying and take this into account and really respect their views. And this is something that I think we are talking about girls 16 or even less, 14 years old, for example. You can listen to what a girl of 14 years old is saying. She's clear, even before that. The authorities can assess, the age and this is even young boys and girls can be listened even when they are very young, 4, 5, 6 years old. There are ways to talk to them, to understand their suffering. The issue here is that we cannot accept the suffering of girls in this situation. And that's why the state is responsible for that. It's not only parents, it's not only the community, it's not only the educational system, but it's the state. The state is responsible for that suffering. And for human rights, the suffering of people is very important. And yes, my colleague was talking about mental health in this situation in the COVID-19. This is also the need for assessing the mental health of children. It's very important, but that's why it's an state party responsibility to provide services, adequate services, to assess, to accompany, to be in this transition, even if they maybe the list should be changed, the laws should be changed. We don't know. As listening to you, it's clear that there are vacuums in the law that should be really discussed and decided. But in the meantime, the transitions between these situations, we have to ask for services for children and for girls in this case that should be available to talk, to be listened, but to be protected, real protection, not control in their lives.
Ms. Otani, your thoughts?
Yes, can I
Yes.
add? Yes, thank you very much. Yes, all what I wanted to say was eloquently addressed, but I just want to add one more point. I want to highlight the importance of empowering because very often we tend to talk about the protection of the children, protective approach, but the children have evolving capacities, and to recognize their agencies and recognize their evolving capacities, we have to address those issues from balancing the protection and also empowerment of the children. And one of the concerns we often see is too much focus on protection, often in the name of the best interest of the child, as if the best interest of the child is only the protection of the children from the harm or from the violence. Of course, the protection of the children from the harms is the rights of the child recognized under the Convention on the Rights of the Child. However, the Convention on the Rights of the Child provides all kinds of the rights of the child, not only the rights of the child to be protected from the harm, but also the access to, of course, education, access to health services, access to information, and all those are important to empower the children and provide all the rights recognized under the conventions. So, and also I wanted to share one more point related to these discussions. The Committee on the Rights of the Child adopted a new General Comment 25 in February this year, and it will be launched this week. This is on the children's rights in relation to the digital environment. So different issue, different topic from topic for us today, but I wanted to share some of the discussion in the drafting process of this General Comment 25. The children appealed to us. Children told us that they don't want the parents or states to prohibit their access to online because they want to learn how to navigate and where the risks and how to protect themselves from those harms rather than being told not to access to those the platforms or the online where of course there are risks. So I think this is one very strong message we heard from the children, and I think it's also relevant to the discussion today. The children have the evolving capacities. They want to have the control over their bodies, and we need to respect and recognize their voice and their agencies. So again, coming back to the protection of whom we are protecting, of course, the intention when we talk about these issues to protect the children, but not protect the children, but protect the all rights of the children provided under the Convention on the Rights of the Child, including their all kind of rights to access to information and have their own identity, sexual identity, and all those comprehensive approach is needed when we talk about the protection. Thank you.
Thank you. We come to a close, and this has been really rich, and I cannot thank you enough for being with us today. And I, as a special word of gratitude for Ms. Acosta Vargas and for Ms. Otani for joining us. We see this as a continuing discussion, so be sure to hear back from us, and very much enthusiastic about exploring much more on this distinction between protectionism and protecting rights. And before we close, because this platform will automatically cut us off, I would request all the panelists in their order of speaking to quickly, 30 seconds, your last thoughts, please. Not sure whether everyone can get their word in, but try to keep it as short as possible, beginning with Binita. Thank you. And
thank you.
Yes.
Thank you, Madhu. To conclude, I would just like to say that in the Nepalese perspective also, the strict law, we should not use it as one size fitted for all approach. And since we have recognized it as harmful traditional practice, keeping it inside the criminal code has made it its consequence much worse. So we need a comprehensive law. And besides, we need more preventive measures to focus on, like in the education of the girl child, adolescent sexual and reproductive health, and overall the programs to reduce and eliminate the poverty in the country. And to work, and we should all work against the equality, work against the inequality in the society and against the root causes of child marriage. Thank you.
Shariar.
Thank you, Madhu. It's been a very enlightening discussion. I would just go on to the point of agency of children. I think that is what Ms. Otani also mentioned. I think that needs to be given emphasis on. And also create awareness in schools to create an enabling environment so that they can decide, and also to talk about SRHR rights. And lastly, for a country like Bangladesh, I would say, and many other countries in the Asia. I think poverty is a reason for child marriages, and there should be social protection mechanisms in place, especially at times of COVID, where a lot of unemployment and economic hardships has been created. Over to you.
Swagata?
Thanks, Madhu. I think what everyone has said deeply resonates with the fact that an absolute position in law is only detrimental to children. And if we look at the law specifically in India, I think they undermine the four core general principles of the UN Convention on the Rights of the Child. There is a clear disproportionate impact on adolescents. One cannot say that it is always in their best interest to be institutionalized. One cannot say that this is serving their development interests as well by invalidating child marriages or criminalizing them. And of course, the right to be heard. Where is their voice in all of this? There is barely any legal representation on the ground. Finally, the one thing I would like to say is we have to look at our international standards as well as domestic laws as enabling health-oriented services for children. They should be able to access information as well as services without any barriers. But the law, as it stands today, is not enabling that in any way.
Maliha?
I'd like to support and agree with everything everyone has said so far. But I think that what's also very important is also what Shahryar was saying, is that we need to ensure the voices of the children are included. In Pakistan particularly, we have a lot of quantitative data about how many child marriages are concluded. We have anecdotal evidence of jurisdictions and cases and analysis of that. What we don't have is actual stories and voices of the children who are in such child marriages, in whatever situation, whether it was voluntary, whether it was consensual, whether it was forced, whether they didn't even know they had a choice. So I think that kind of information is very missing, because I think that kind of thing adds a powerful element to a lot of the advocacy that we do. And links up with the point that Ms. Vargas was making earlier on as well, is that when we're talking about protection and creating a system that is a safety net for all of these children, because many of them do enter into child marriages as an escape from an already abusive or restrictive household. What are the different avenues of escape that we should be providing for them as opposed to child marriage? And I think that has to come from the voices of the children themselves.
Right. Thank you. Tehani? Tehani, are you with us? She seems to have got cut off. Marissa, could you go?
Yes.
Yes.
Can you hear me?
Yes. Yes, we can.
Thank you. Yeah, thank you so much. I really appreciate all the inputs, and I agree with everything that has been said. I think what I want to say here in terms of a final thought is that thinking about adolescent girls and young women who do enter these unions and marriages consensually, I think what is important, Maliha also spoke about this, is requiring us to think about both how we do our advocacy, but also how we demand resources goes towards expanding the list of options for adolescents and their families in the communities that go beyond marriage and early unions. I think the idea around focusing on child's early enforced marriage laws need also to be thinking about how we support communities and their livelihoods, so that the list of options and choices that girls can make about their lives can be expanded. And finally, I think it's really important, and Ms. Vargas said, Acosta said this as well, it's that there needs to be a space where girls and adolescent girls in particular can experience their sexuality outside of this framework of marriage. Thank you so much.
Thank you. And since still we have a minute, so let me just thank the interpreters by name. Very, very strong thanks goes out to Maud, Jimena, Dina, and Ilavati for translating in Spanish, French, Bangla, and Nepali. Thank you so much. You've made it a much more inclusive event. And also all the back-end moderators, Mrinalini, Surabhi, Udita, Nadia, and please, am I missing out some Amna? Any other names I'm missing out? Please let me know. So thank you very much. PLD also has an event on the 24th. to talk about the issues on child marriage in India, particularly given the proposal to increase the minimum age to 21 years. Please join us on the 21st. We're a national coalition and would love to have all the people regroup at that meeting. Thank you and bye-bye.